Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy developments every 2 weeks. That's right, we are moving to a 2-weekly schedule for these Privado-sponsored videos and newsletters, but I'll still record the occasional video for my own purposes too. So this week, firstly, Vermont's privacy law, very ambitious law, was vetoed, and the legislature there refused to recover it. So we'll see what everyone's so scared about when it comes to this bill. Meta has delayed its policy of training its AI models on users' posts, and noyb is taking the credit, rightly or wrongly. Let's take a look. The ICO has dropped enforcement action against Snap. They published some details about that today. So we'll look at 10 things Snap did right, according to the ICO. First up then, Vermont. So H121 was a very ambitious privacy bill that has been vetoed by the state governor. The legislature had the chance to reverse this decision and declined to do so. The governor's main issue with this bill was its private right of action. So far, among the states that have passed comprehensive privacy laws, only California implemented a private right of action. And that private right of action is very narrow. It's tied to the state's data breach notification law and only applies in certain circumstances. Vermont's too went through a whittling down throughout the negotiations around the bill and would have been quite narrow too, deferring to the Attorney General to come up with something that took small businesses' interests into account and balanced against consumers' rights. But the governor was still not happy with this. They also criticised the Kids Code attached to the bill, this sort of age-appropriate design code act that recently has been challenged on First Amendment grounds in California with some success. So he felt it was too risky to implement a law like that. Overall, I mean, it was quite a strong bill on many accounts. So there was a data minimization rule that didn't go quite as far as Maryland did in that same week. They passed a very strict privacy law with data minimization requirements, but still it stood out among the states as being quite a novel approach to a comprehensive privacy law. So on Monday, the House and the Senate had a chance to overturn Governor Scott's veto, and they chose not to. According to VT Digger, a local news website, they reversed a record-breaking 6 vetoes that day, but H121 was not among them. The vote at the House was overwhelmingly in favour of reversing Governor Scott's veto, but the Senate declined to do so by just 1 vote. So we came very close to having this law enacted in Vermont, but it didn't happen. Now, I feel this might make state lawmakers elsewhere a bit more timid. These comprehensive privacy laws are getting more and more interesting after a period where everyone was just copy-pasting Virginia's law. Governor Scott is saying, let's pass Connecticut's privacy law instead and ensure some regional consistency. Maybe they'll have another go in Vermont with a simpler law. Let's see, watch this space. So in Ireland, or Europe more generally, Meta has decided not to go ahead with its plan to train its AI model on users' posts. And, well, this is a bit of a confusing story because initially Meta had said it had already delayed at the behest of the Irish DPC and had put a number of mitigations in place to satisfy the regulator. But then last Friday, the Irish DPC said it welcomed Meta's further delay to this AI training policy due to the intervention of other EU regulators. So Meta, for its part, says it's disappointed by the DPC's decision on behalf of the European DPAs to delay our large language models, the training of their large language models using public content. They say, probably quite reasonably, that they're only doing what competitors are doing here in not seeking consent for AI training. So Google and OpenAI, they reference specifically. And they actually say they went further than those companies by offering quite a transparent, convenient opt-out. noyb, the privacy campaign group headed by Max Schrems, put in 11 complaints about this policy, as we saw a couple of weeks ago on the Privacy Corner. And they are taking credit for Meta's decision to delay. I think that's probably reasonable. I mean, one of these DPAs or more has probably jumped on this, as noyb expected them to, and maybe even threatened to use the urgency procedure under the GDPR and put pressure on the DPC to put pressure on Meta to delay. So whether this is a permanent delay or until further notice, we'll see. Meta will probably return to this plan in future, I would imagine. Lastly, the ICO, the UK's Data Protection Authority, nearly enforced the GDPR against Snap. Late last year, they said they had a preliminary enforcement notice against Snap. It's all to do with the My AI feature in Snapchat. So this is a GPT wrapper, essentially, an implementation of ChatGPT within Snapchat that Snapchat users can talk to. And the ICO was quite concerned about Snap's risk assessment, as they insisted on calling it, the data protection impact assessment, and whether or not they had taken the rights of children into account sufficiently. So it looks like Snap ended up on their 5th iteration of the DPIA before appeasing the ICO, and I picked out 10 things that appear to have put the ICO's mind at rest when it comes to AI, children's data, those sorts of things. Firstly, the first 3 all relate to the DPIA itself and how it presents information about the processing. So firstly, there was a more detailed breakdown of the processing operations in time for the 5th draft. The possibility of, or the inevitability of, processing special category data was sort of, Snap faced up to this reality and said, we are going to be processing special category data here because someone will inevitably feed that in as an input into my AI. They don't appear to have done anything about that, but it was enough for the ICO that they considered it. And also the age appropriate design code, or the children's code. This is an IPO code of practice in the UK. Snap appears to have deferred to that and gone through the 15 principles thereof and assessed its processing against that, which the ICO liked. Next up, they were either inferring or using a declaration of the user's age and putting them into an age bucket, sharing that with OpenAI and instructing OpenAI to only output age-appropriate content depending on the user's age. Fifthly, they gave child users a clearer, more accessible just-in-time notice and instructed them to speak to an adult if they're unsure about the information provided by my AI. So basic transparency stuff. Number 6, they allow parents to see whether their teenager is interacting with my AI through Snap's Family Center, and also enabled parents to turn my AI on and off on their child's account. So this is a bit of a controversial approach, I guess. In general, I think they're balancing child safety over child privacy here, but the ICO clearly approves of that. So one to note there if you're developing children's products. Next, the Snap put some controls in place aimed at limiting the risk that 13 to 17-year-olds may use my AI as a substitute for completing their school homework. So obviously some sort of filter that identified prompts saying, write me an essay or whatever, and instructing the bot to not do that. Number 8, 9, and 10 are all grouped together with kind of data minimization and purpose limitation stuff. So they made my AI off by default. The ICO obviously liked that. They enabled users to delete data processed in connection with my AI, and they also limited the amount of data from other areas of Snap and from third parties that they processed in association with my AI. Another interesting thing here, the ICO preliminarily said that Snap had violated Article 36.1 of the UK GDPR, which requires controllers to consult with the ICO if they do a DPIA and there are still residual risks that can't be mitigated. Now, it looks like an earlier version of SNAP's DPIA said there were residual risks that could not be mitigated, but SNAP did not consult with the ICO. The ICO says it believes SNAP when SNAP says that was an accident and they didn't mean to write that. And in fact, there were no residual risks. They seem to have got some sort of signed witness statement attesting to this, and the ICO is willing to take their word for it, so will not be pursuing a violation of Article 36. So that's all from me this week. As I said, we're doing these every other week now. So thank you again to Privado AI for their support, and I will see you in 2 weeks.